I'll adjust it as we discussed. Okay. Let's go ahead and get started to be respectful of everyone's time. I'm Mike Burgess. I represent Texas 26th District, part of Fort Worth and Benton County up the Red River. Joined by most of my colleagues on the Republican side of the Texas delegation. On Tuesday, Texas Attorney General Greg Abbott and 12 state attorneys general filed a legal action challenging the constitutionality of the recently enacted federal health law. Bipartisan legal challenge explains that the new law infringes upon America's constitutionally protected individual liberties, encroaches upon the state's constitutionally guaranteed sovereignty, forces states to spend billions of additional dollars on entitlement programs, imposes an unconstitutional tax, and violates the 10th Amendment of the United States Constitution. No public policy goal can be allowed to trample the protections and rights guaranteed by the United States Constitution. We have obviously many members who wish to speak. We're going to go immediately to our ranking member on the Committee on Energy and Commerce, Mr. Barton, and then I will introduce the other members as they come up.
Well, first of all, I want to thank Congressman Burgess for arranging this press conference in response to the Democratic members of the Texas Delegation's conference just earlier. I spoke with Attorney General Abbott about 30 minutes ago. He assures me that this lawsuit is necessary to protect the welfare of the citizens of Texas. He and 13 other attorney generals are filing in Florida in federal district court. As Dr. Burgess has just pointed out, the primary focus of the lawsuit is the constitutional guarantee that all those powers not directly enumerated to the Congress and the federal government are reserved to the states and the individuals. And there is a real constitutional question whether you can force an individual to take a service and a product that they of their own volition would not wish to take. It would have been as if in World War II, when we were trying to save not only the United States but the entire free world, the federal government had told every American citizen, not only you have to buy war bonds, but you have to buy this kind of a war bond, this denomination of a war bond. The lawsuit should be heard at the district court within the next 3 to 4 months, and there would be an appellate, and then hopefully it will be before the Supreme Court within the year. This is the first of many lawsuits and efforts to repeal parts of this law. One thing that's in the law that I don't think too many people understand is that beginning in 2014, if you're Medicaid eligible, in other words, if you are below 133% of the federal poverty limit, whether you want to be or not, whether you have insurance or not, you're going to be covered by Medicaid, period. Something else that's in the law, in the law that's not a part of the lawsuit, but I think is interesting, is the people that actually drafted the bill. That is the staff members of the leadership and committee staffs are exempt from the bill, exempt from the law. I just found that out this morning, and I think that's an interesting fact point. So I'm totally supportive of Attorney General Abbott's filing of this lawsuit. It's going to cost the state of Texas, just in Medicaid eligibility funding alone, $24 billion over the next 10 years. That's over $2 billion a year. That's money that the state of Texas is going to have to raise through increased taxes or by cutting other programs. And I believe that what Texas and other states may do is decide to opt out of the Medicaid program in its entirety, and then you're going to have an even heavier burden on the federal taxpayer for this ill-founded, ill-conceived law that's now the law of the land.
Thank you, Chairman. Well, next we'll hear from the Senior Appropriator from the 12th District of Texas, Kate Ranger.
Thank you, Michael. The Texans, Texans have said that they don't want this bill. They think it's bad medicine, and they also can't afford it. And Joe Barton just talked about $24 billion over the next 10 years is the cost to the state of Texas. This includes $6 billion reduction in the funding to our state hospitals. Doesn't take into account the cost to businesses, and businesses are phoning all of our office now and say, what does this really mean to me? And this is what I pay for insurance a day. What's it going to cost? And then what's it going to cost for me to drop the insurance for my employees and just pay the tax? So when we talk about the cost of the state of Texas of $24 billion, we also have to take into consideration the cost to businesses, the cost to hospitals, the enormous weight it's going to put on nursing homes and home health care. People are telling me there will be no business, no industry left. The loss to doctors leaving medicine and leaving the profession. It's a very, very serious thing. We're taking it very seriously. People have been calling us for months and saying, I don't think this is constitutional. We'll certainly find out.
Okay, the Dean of our delegation, Ralph Hall.
Thank you. And I think for the first time in the nation's history, the federal government is trying to force individual Americans to enter into contracts. And pretty clear the Constitution is what's not specifically set out for the feds, rest with the states. But that's not the only way to attack this. About a month ago, or maybe 6 weeks ago, I made a speech on the floor calling attention to U.S. Code 203 of U.S. Code Section 203. And that's about compensation to members of Congress and offers, and basically alludes to bribes. For the 2 or 3 weeks that we handled the case in Energy and Commerce, we had it beat down to where within 5 votes on the floor, out of 40 votes, they passed by 5 votes, which we beat the bill down to where the Senate should have been able to go on and foreclose it. But instead, they started drawing lots to see who's going to be that 60th vote and being bribed and taking bribes. A bribe's a violation of the law. Now, I understood yesterday, I believe, or the day before yesterday, that they'd indicated that they were not going to go through with the bribe. But the bribe's already been made. And the bribe is a $50,000 fine and a year in jail for anybody that bribes under this circumstance. Now, the bad part of that to the members of the Democratic Party is a 5-year statute of limitation. If we don't get the floor back in November, we're going to get it back in November 4 years from now. 5-year statute, it looms over. The act has already occurred. They can't take that back.
Thank you, Ralph. We are very fortunate in the state of Texas to have fine legal minds in our delegation, and one of the finest is the representative from the 31st District of Texas, Fort Hood and Georgetown, Judge John Carter.
Thank you, Michael. This is an interesting concept. It's a great concept for us to think about. I've got the things that the Democrats have raised, the issues they've raised, and somewhere I got them in here. And I want to just point out that everything that they have raised is just rhetoric. It's just political rhetoric that takes place in this room. But the good news is that our United States Constitution and our founders gave us a place to have problems solved, not just rail about them in the public forum. And our Democratic colleagues have railed about it in the public forum. They've asked, where does our Attorney General get the authority? We are a constitutional republic. We are not an autocratic European socialist nation. We are a constitutional republic. And we are a republic where decisions are made at the state level with constitutional authority. We hired our Attorney General at the ballot box to represent the people of Texas and the state of Texas. But that's not for us to decide. That's for the courts to decide. If they think it's frivolous, if they think the Attorney General doesn't have the authority to come in and represent his clients in the courthouse, then file their lawsuit. If you think that we're wrong, if you think the state's wrong, the Democrats need to step up to the plate and file a lawsuit. Because the truth is, the courts solve problems. We seem to create more than we solve here. But ultimately, when it gets to the United States Supreme Court on the Constitution of the United States, that's where it belongs. That's where the founders designed it to be. And that's the recourse that every citizen and every state in this union has to solve problems. And so the truth is, let's stop the rhetoric. And let's go where the Constitution designed us to go, and which our Attorney General and 13 other Attorney Generals are doing. Democrats and Republicans, let's point out, Attorney Generals, we're going to the court of last resort, the Constitution of the United States and the United States Supreme Court. It is proper, it is what we should do, and we should respect that process. And it's unfortunate rhetoric does not respect the process.
Thank you, Judge. And we'll hear from another Texas judge, Judge Louis Gohmert from East Texas.
Thanks, Mike. To follow up on what Judge Carter was saying, I think it's important to note a question that's been asked, where does Attorney General Abbott get the authority to go file a suit? The legislature has not given him the authority to file suit. You got to think about that. If the Attorney General of Texas has to wait for permission from the legislature to file a suit to protect Texans from even most egregious conduct, then the message to the rest of the world and the country is the best time to attack Texas and hurt Texas legally is during an even-numbered year, because the legislature's not meeting, and apparently, according to some who haven't studied the law closely enough, that the Attorney General can't protect Texas except when the legislature's in session and says okay. Obviously, that's not the case. Attorney General's hired to do what is legally necessary to protect Texas, and that's exactly what our Attorney General, Greg Abbott's doing. Now, this is an unfunded mandate. This is a further usurpation of states' rights. This is a usurpation of the people's rights. I know our president has said before, well, look, states require you to buy car insurance. This is just requiring you to buy health insurance. There is a huge difference. There is not a single state in the entire union that requires you to buy insurance just for breathing or living. If you have a car and you want to utilize the privilege of driving on the roads, then yes, you buy insurance. But there's not a state in the union that requires you to buy insurance to protect your own car's damage or your own personal damage. You have to buy insurance to protect damage you might do to someone else or someone else's property. So this is a whole different thing that has never been done before. It is such an egregious abrogation of constitutional rights. The states are not entirely without power. Some have said, well, we'll have to wait, and this is one potential. Even if Republicans took the House and sent it back in November, we probably wouldn't have a 2/3 majority to override any veto by the president. So it would take that early window in 2013 to repeal this so we could replace it with true reform and not this egregious activity. But the other possibility is Article 5. And it's the part of Article 5 that has never been utilized before. And that is that when 2/3 of the states feel there's something so terrible, so unconstitutional, just wrong that's being done, they can demand an amendment constitution, not a constitutional convention, but an amendment convention rather. And at the amendment convention, you can draft amendments. Then it takes 3/4 of the states to ratify those. You don't even need the president's permission to do that under Article 5. Now, the last time it was talked about was a repeal of prohibition, and Congress got so scared when they had nearly 34 states that they rushed in and did 2/3 of the House and Senate and then got the 3/4 ratifications from the state. I'm not advocating repeal of the 17th Amendment. I'm saying there's solutions to finally put back after 97 years some kind of check on this federal usurpation of states and people's rights. The 9th and the 10th Amendments are the most abused amendments in the Constitution. It's time to do something about it. At that amendment constitution, some of the suggestions have been, well, give states the right, say 30 days or so after a bill is enacted, have 3/4 of them have the right to veto that bill. If it is such a burdensome, inappropriate law that's passed by the federal legislature, then let them have a chance to veto. There are a number of them. Some have proposed
allowing states not to have the legislatures elect the Senate as they did before 1913, but to have them have the right to recall a senator when he takes away a state's rights. So there are a number of solutions, but ever since 1913, when the 17th Amendment repealed the state legislature's right to select senators, there has been no check on runaway federal rights and federal abrogation of states and people's rights. So we got to get that back in check, and it could happen before 2013. And if for those who are afraid of the states and people rising up and saying we're going to act within the Constitution and we're going to get you back under control, you have a real reason to be afraid. They may just do it.
Thank you, Louis. And Texas is also fortunate to have someone who worked in the Attorney General's office in Texas, former federal prosecutor Mike McCall, in the district.
Thank you, Michael. I worked in the Justice Department. I also worked in the Texas Attorney General's office with now Senator John Cornyn. I want to comment on Mr. Hall's comments. The sweetheart deals, in my view, agency, the Congressional Research Service, expressed doubts about the Commerce Clause applicability in a report that was issued last July, saying that despite the breadth of powers that have been exercised under the Commerce Clause, it is unclear whether the clause would provide a solid constitutional foundation for legislation containing a requirement to have health insurance. It may be argued that the mandate goes beyond the bounds of the Commerce Clause. This isn't us talking as Texas Republicans. That's the Congressional Research Service. In addition to that argument, and this is a copy of the lawsuit right here, in addition to that is a $25 billion unfunded mandate on the state of Texas. A mandate that the majority of Texans don't want. And in the lawsuit, I think it frames it well when it talks about this unfunded mandate, that this act violates the 10th Amendment of the Constitution and runs afoul of the Constitution's principle of federalism by commandeering the plaintiffs and their employees as agents of the federal government's regulatory scheme at the state's own cost. This is a bad bill. That's why we voted against it. I stand in support of our Attorney General in this lawsuit. I believe it will go to the United States Supreme Court, and let's hope that the Founding Fathers' vision for this country will be fulfilled. Thank you.
Thank you, Michael. And in addition, in Texas, we have one of the best numbers guys in Congress, Mike Conaway.
Well, thank you, Michael, and I'll leave it up to my learned legal scholars to talk about the constitutional issues. While I do believe it's the mandates are unconstitutional, the other issues that are unconstitutional, my friends have said, you will see, as we've seen over the last day or two, the business impact that this ill-fated law will have. Caterpillar has already announced that they're going to have significant costs per year increases. Verizon has announced today in a letter to their employees that their company has got significant increase in healthcare costs. Those healthcare costs will reduce jobs, will reduce compensation to these employees, and will be a direct impact. It will also immediately lead to the loss of insurance that they like. And I don't know if that's a takings under the Fifth Amendment, but it sure looks like that the federal government has taken away from the general public an opportunity to provide for themselves health insurance that they want and they can afford. This will increase costs, it will increase premiums, and it adds to the urgency that these lawsuits go forward. And I too support Greg Abbott and his efforts to push this through the Supreme Court sooner rather than later. Thank you.
And finally, the newest member of our delegation, Navy veteran from Houston, Pete Olson.
Thanks, Dr. Burgess. The numbers say it all. $500 billion in Medicare cuts for seniors. Over $500 billion in new taxes for small businesses. And what we're here to talk about today, a $24 billion unfunded mandate, Medicare mandate on the state of Texas. And I'm proud to stand here in support with my colleagues of our Attorney General. You know, as the freshman running around here, the first one, I was campaigning in this current environment. And I can tell you at some of the meetings we had, people in our state are very, very concerned about how much the federal government is overreaching into their private lives. In fact, at one of the town hall meetings we had, an individual stood up and said, "What's the most abused part of our Constitution?" Easy answer. I worked for Phil Graham for 4 years, so this was sort of a mandatory issue for him. Constitution Declaration of the United States. I'll read to you the 10th Amendment, just because everybody needs to. There's a reason the Founding Fathers put the amendments in the order they did. You know, the First Amendment, freedom of speech, freedom of the press, freedom of religion, and then they got down to the 10th Amendment just to make sure that everybody understood what they meant with the Constitution and the amendments. Here's the text, one sentence. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. This unfunded mandate, this requirement to purchase health care, is in violation of the Constitution. I stand here in strong support of our Attorney General and my colleagues. Thank you.
I think that concludes the comments from our members. You've heard almost every argument that could be made. I think one of the big bottom lines that we've heard from a number of our state legislators, state senators, is they simply cannot afford this hit to their biennial budget. So with that, let me open it up to questions. You've got some fine legal minds here. If there are any medical questions, I'll take them. The legal questions will be answered by our judges and prosecutors.
And I'll answer the easy questions.
I'm wondering, there's been a lot of talk, it's going to go to the Supreme Court. I don't know how long it's going to take. Obviously, it'll take a while. Are you all prepared to abide by a ruling not in your favor from the Supreme Court? If I understand that you're all confident the Supreme Court would rule in your favor, but if they don't, what then?
Well, we believe in the rule of law, and as far as I know, every member of the Texas Republican delegation supports the judicial system. We've got several former judges, and Congressman McCall was a federal prosecutor, so you know we'll abide by whatever the Supreme Court says. I might also point out that Congress has the right to change this law, and Congress also has the right to interpret the Constitution. It's a misnomer to say that the only arbitrator of the Constitution is the Supreme Court. The Congress has just as much right to interpret the Constitution as the Supreme Court does. But in this circumstance, it's a federal lawsuit being filed that would go to the Supreme Court, sure. I want to make one other comment on what's actually in the bill. The thing that my friends that voted for it are most proud of is that people with pre-existing conditions can immediately get insurance. That's not quite true. It's kind of half true and half not true. There's a fund of $5 billion for the first 4 years that goes to each state to set up a high-risk insurance pool in each state. You can apply within 90 days if you have a pre-existing condition to get insurance through this high-risk pool. And some American citizens will get it. But because it would cost a lot more than $1.25 billion a year to cover all the people in the country with a pre-existing condition who today do not have insurance, you're going to create a waiting list in each state. And yes, some people who have not gotten insurance will get it, but there are going to be lots of people in spite of what my friends on the other side say, they're going to be put on a waiting list because $1.25 billion is not enough money to provide for insurance for the 8 to 10 million Americans who today don't have health insurance because of a pre-existing condition.
Todd, it's not just apparently the Republicans that think this is unconstitutional. And of course we believe in the rule of law. We follow the law. As a judge, I followed the law like I know Judge Carter did, even when we didn't like it. Thought it was wrong, because that's what we do. That's what holds us together and keeps us from being a third world nation, following the rule of law. But apparently there are a lot of Democrats that are scared that this will be considered unconstitutional, because in both the House and the Senate, the efforts to fast track this straight to the Supreme Court, cut through the years that it may take to get there, were fought just viciously by the Democrats. They didn't want a quick ruling from the Supreme Court because they had a feeling they knew which way it might go. So they were hoping to delay it 5, 6, 7 years, well beyond the time when the federal government may drive a lot of private industry out of the healthcare business. So then they'll say, well, gee, you know, we've driven all these other people out of business. We'll just have to do a tax then and take over what we've already done. So that's why it's even more important that we move forward quickly. And let me just mention, following up also, what Joe has said about the law. You know, normally, when someone takes money away from you when you don't want to give it up, it's called stealing. But under the Constitution, this body up here has the right to steal from you if we pass a law that says it's okay. And we can use our IRS agents and we can use our Army, whatever we got to do to go get your money, even though you don't want to give it up. It's legally appropriate, but it's not morally appropriate. And for those who say, well, you say you're a Christian, we've heard this allegation, you say you're a Christian, and Jesus said, help the widows and orphans and the poor. And the fact is, if you go check the entire New Testament, Jesus never said, go ye therefore, use and abuse your taxing authority and take other people's money to help over here. He said, you do it. You do it with your own money. Not go take somebody else's. Don't abuse the process. Do it with your own money. That's charity. And it makes you a better person by doing that. And if you want a real example of what was done in the Bible, the first thing Zacchaeus did after he met Jesus was go and cut taxes.
Todd, I would just make two quick points. One is that in the law, there's provisions that if the states don't set up exchanges, the federal government will, the Office of Personnel Management will. This is in fact a backdoor public option that many people are not aware are in the bill. And then Joe had a great point. If the state is forced to take additional Medicaid enrollees, the states may decide to opt out of Medicaid. So, yeah, we'll follow the law, but there actually are there's some leeway. Let's take 2 more quick questions if we could. And I know we've got other people that need to come in.
Can you talk a little bit about, because Congressman Barton mentioned the Medicaid thing, a little bit more about the state opting out of Medicaid? Where sort of did that come from with Texas specifically?
Well, one state, the state of Arizona, has already decided to opt out of the SCHIP program, which is a low-income program for children. They're just above the lowest eligibility level for Medicaid. As states see what this is going to cost their budgets, it is not a requirement that every state participate in every federal program. The states have the right to, if they take the money, they have to apply by the rules of that particular program. But if they choose not to take the money, they don't have to. And this Medicaid expansion in most states is going to double the Medicaid population. It won't happen in every state, but in most states. And for the first 4 years, the federal government, because of the Nebraska, the Cornhusker kickback, the federal government is going to assume 100% of that cost. That started out to be just for Nebraska. And then because of the uproar over that, the solution was not to drop it for Nebraska. The solution was to give it to every state. So for the first 4 years, every state gets 100% reimbursement for their Medicaid expansion. But after that, it stops. So the states are going to double their Medicaid population, have all these huge increases in cost, and then they're going to have to absorb all those costs when the federal government reduces the FMAP. And I think it's a fair question that a lot of states are going to say, they're gonna look at this bill and see all these mandates in it, and they're gonna say, okay, we'll drop Medicaid, maybe come up with an additional program that's state funded for our children, and let the federal government take over the program. And that's a real possibility.
And if you read the pleadings that have been filed in the 2 or 3 lawsuits that have now been filed, they all point out that Medicaid is a contract between the state of Texas or any state and the federal government. And we set out rules, they set out by which they are contracted. One of the arguments that's made, I'm not saying lesser arguments, but one of the arguments made is that one side of a contract can't impose completely new things on the other side without that other side having the ability to say, we don't want to be in the contract anymore. And so this is what the way of a lot of the state's attorney generals are looking at this, is there are huge additions to Medicaid being imposed by one side of the contract, the federal government, without the acceptance by the other side of the contract, which is the state government. And that's why they may, Joe's right, they may just say, we don't want a contract anymore.
Okay, last question, and I think we have to get out of here. No further questions. Thank you all very much for coming out. Thank you guys.